Okay, let's unpack this. Imagine a really powerful legal battle playing out right now, highest levels of government, and it's one that, well, it touches every single person in the country, even if you don't realize it yet. Today, we're taking a deep dive into the recent Supreme Court action regarding Executive Order number 14210. That's an executive order aiming for what it calls a critical transformation of the federal government.
That's right. And our source material today, it's coming straight from the Supreme Court itself. We have a recent order dated July 8, 2025, and this includes, the main decision, but also a concurring opinion from Justice Sotomayor, quite nuanced, and a really powerful dissenting opinion from Justice Jackson.
Right. So our mission here in this deep dive is really to help you understand this pretty complex legal fight. What's actually happening on the ground in federal agencies because of it? What's the crucial historical context that makes this decision so significant? And of course, what are the potential ripple effects for you? And just quickly before we jump in, it's really important for us to note, our role here is just to impartially report on what's in these documents. We want to help you understand the arguments, the perspectives being presented, without endorsing any particular viewpoint. We're simply conveying the ideas from the source material, making sure we give a balanced picture of the different views. Okay, so let's dive right in. The immediate outcome. What exactly did the Supreme Court decide in this case, Trump v. American Federation of Government Employees?
Well, the headline is, the court granted the application for a stay.
A stay. Okay, remind us what that means exactly.
Right. A stay basically means hitting the pause button on what a lower court decided. So in this situation, it freezes or stays the preliminary injunction that the U.S. District Court for the Northern District of California had issued. That was back on May 22nd, 2025. That injunction, remember, was in order to temporarily stop the executive order from moving forward. So this Supreme Court stay, it's going to remain in effect while the case works its way through an appeal in the Ninth Circuit Court and also through any potential petition for a writ of certiorari to the Supreme Court itself.
Which is basically asking the Supreme Court to take a full look later on.
Exactly, asking for a full review down the line.
Okay, so they hit pause. What was the court's stated reason for doing that? What was the basis for this decision?
Their stated reason is that the government is likely to succeed on its argument that the executive order number 14210 and that joint memo from OMB and OPM that implements it, that they are lawful. So basically, the court thinks the government has a strong chance of winning the whole argument on the merits if this case goes all the way.
Interesting. And did the court say anything about the actual reorganization plans themselves, the specific agency plans?
No, and that's a key point. They were very careful there. The Supreme Court explicitly said they express no view on the legality of any specific agency RIF and reorganization plan that might be produced or approved because of the executive order and the memo. You see, the district court had stopped things because it had doubts about the legality of the main executive order and the memo itself, not necessarily the individual agency plans that came from it.
Okay, so the court's main decision is pause the injunction because the government probably has a winning argument that the overarching order is legal. But, as often happens in these big Supreme Court cases, even justices who agree on the result might have different reasons. How did Justice Sotomayor, for example, kind of explain her agreement with granting the stay?
Right. Justice Sotomayor did agree to grant the stay, yes, but she added a really important emphasis. She stressed that while the president can restructure federal agencies, it absolutely cannot be done in a manner inconsistent with congressional mandates.
Okay, so consistent with what Congress wants.
Exactly. And her key justification for agreeing with the stay was that the executive order itself actually directs agencies to plan these reorganizations and RIFs, or reductions in force, consistent with applicable law. And the joint memo says the same thing. So she specifically pointed out that the actual specific reorganization plans, they are not before this court at this stage.
Okay.
Which means the district court is still free to look at questions about whether those specific plans can and, will actually be carried out legally within all the existing constraints.
Got it. So that's the majority's view and Sotomayor's concurring view. But as you hinted, there was a very strong dissent in this case. Justice Jackson, she painted a fundamentally different picture. What was her core argument against granting this stay?
Yeah, her dissent really presents a fundamental challenge. Her primary point is constitutional. She argued that, under the Constitution, it's Congress that has the power to establish administrative agencies and spell out what they do. So because of that, she asserted that presidents, well, for the past century really, have always first obtained authorization from Congress when they've tried to significantly reorganize the federal government.
Always ask Congress first.
That's her argument based on history. She described this Executive Order 19210 as a sharp departure from what she called this settled practice. She essentially asserts the president is, quote, allegedly arrogating this power to himself. How? By ordering this critical transformation through eliminating or consolidating agencies and ordering large-scale reductions in force, RIF Saul, without getting congressional buy-in first.
Wow, that's a really strong claim about stretching executive power. Let's unpack the history she provided. How have presidents typically handled big government reorganizations? Does the history actually back up her claim that Congress always had a say?
It does, according to her dissent, which really dives into the historical record. She noted, for example, that Congress first gave general reorganization authority way back to President Hoover in the 1930s. They specifically delegated authority to transfer, consolidate, and change agency functions. And since then, Congress has granted a similar authority, though, importantly, usually for limited time periods, to 8 other presidents. We're talking FDR, Eisenhower, Kennedy, Nixon, Carter, Reagan.
So quite a few.
Right. But here's what she highlights as the crucial part. All these many reorganization acts that Congress has passed since 1932 vary in the degree of discretion conferred. But all, she emphasizes, have given Congress a say before the president has implemented any proposed plans.
Oh, Congress never just handed over the keys, essentially. They always kept some control.
Exactly. She points out that Congress actively managed this power. They've amended, extended, narrowed, or reactivated this kind of government reorganization authority 16 different times over the years. And get this. Out of 126 reorganization proposals presidents submitted under these acts, 93 went through, but 33 were affirmatively rejected by Congress.
Rejected by Congress.
Okay. And another key historical fact she raises, the last big comprehensive reorganization act. It expired back in 1984, and it hasn't been renewed since.
1984, so it's been a while. Have presidents tried to get that power back more recently?
Yes, absolutely. And her dissent gives examples of recent rejections by Congress. In 2012, President Obama asked Congress to bring back a modified version of that 1984 act just for 2 years so he could consolidate some business and trade agencies. Congress never passed the bill. President George W. Bush and President Trump, in his first term, also tried to get reorganization authority and were unsuccessful.
Okay, so if that's the history for major reorganizations, how does Justice Jackson explain times when presidents did make workforce cuts without maybe explicit new laws?
Right, she addresses that too. She acknowledged there's precedent for smaller-scale workforce reductions without specific prior congressional authorization.
Yeah.
She uses President Clinton in 1993 as an example. He reduced the federal workforce by about 4%, mainly through attrition, over 3 years. But, she points out, his order did not mandate reductions in force or reorganizations in the same way. And, importantly, President Clinton also later obtained congressional authorization for his plans.
Ah, okay. So even then, Congress was involved later.
That's the distinction she draws. So the historical takeaway, according to Justice Jackson's dissent, is clear. While presidents do have some discretion to trim federal employment, they may not fundamentally restructure the federal government all on their own. Why? Because administrative agencies are created, funded, and given their tasks by Congress.
Okay, that historical context is crucial. So given that history of deep congressional involvement, what did the district court, the lower court, actually find was happening on the ground with this specific executive order? What were the facts they were looking at?
Right. Justice Jackson really emphasized that the district court's central question was primarily one of fact. And the district court, she noted, received extensive evidence from the plaintiffs, the ones challenging the order. We're talking 68 sworn declarations, over 1,400 pages, and comparatively scant submissions from the government side, just a single declaration. The judge also did an in-camera review.
Meaning reviewed privately?
Exactly. The judge reviewed several proposed agency reorganization plans privately in chambers, and based on all that evidence, the district court found that the plaintiffs were likely to succeed in showing that this executive order and the memo weren't just about minor RIFs allowed by existing law. Instead, they found it looked like it sought to effect a fundamental transformation of the federal government.
Fundamental transformation, not just trimming the fails. What specifically did the district court find that led them to that conclusion?
Well, they found that several federal agencies were in the process of rapidly implementing reorganizations and large-scale reductions in force. And the court also determined that if this restructuring wasn't paused, many agencies will not be able to do what Congress has directed them to do. Why? Because the proposed changes appeared to, quote, intentionally or negligently flout the tasks Congress has assigned to those very agencies.
Can you give us some examples? I mean, the scale of these changes highlighted in the dissent must have been significant for the court to reach that conclusion. What kind of numbers are we talking about?
Absolutely. The numbers highlighted are, frankly, staggering. The dissent points out the district court highlighted plans to terminate more than half of many agencies' staff, and in some cases, to practically wipe out entire agencies.
Right, Bow.
That's the language used. Specific examples of proposed cuts included approximately 93% of employees at the National Institute for Occupational Safety and Health.
93%. Wow.
Nearly half the workforce at the Department of Energy. More than half the workforce of the National Oceanic and Atmospheric Association, NOAA. Proposed cuts of 70% of staff at the Department of Labor's headquarters. And proposed cuts that would affect 83,000 workers at the Department of Veterans Affairs.
83,000.
And this wasn't just talk. As of May 16th, the district court found about 40 actual reductions in force were already in progress across 17 different agencies.
Wow. Okay. Those figures are incredibly stark, and I think they really underscore Justice Jackson's point that, in her view, and based on the district court's findings, this wasn't just bureaucratic trimming. These were proposals that could essentially dismantle agencies. So given those extensive factual findings by the district court, based on all that evidence, how did Justice Jackson then view the Supreme Court's decision to step in and grant this stay anyway?
Well, her criticism of the majority's decision was very, very strong. She argued the court rushed up the chain of review, instead of just letting the lower courts fully hash out the merits of the case first. She contended that the majority focusing so much on the likely merits, whether the order was ultimately legal, was problematic here. Why? Because the district court's decision to pause things was based heavily on findings of fact.
Right, based on those declarations, those plans.
Exactly. And in her view, it is not this court's role to swoop in and second-guess a lower court's factual findings, particularly when, as she put it, they are well-reasoned preliminary judgments on a developing record. She wrote that the court casually discarded 55 pages of evidence-based lower court reasoning, and that its very brief, one-line conclusion that the government is likely to succeed. Well, that conclusion must rest, she argued, on a conclusion that the district court was wrong about the facts of what is really happening.
So essentially, she's saying the Supreme Court majority substituted its own view of the facts for the district courts, without the benefit of the full record.
That's the core of her procedural criticism. She also emphasized that stays are supposed to be extraordinary relief. You need a strong showing that you're likely to win on the merits. And she believes the government failed to make that strong showing, especially because the whole dispute was so dependent on these contested facts about what the order was actually doing on the ground.
Okay, so the dissent is arguing the Supreme Court jumped the gun, ignored the facts found below. Let's bring this back to the listener then. If these plans under the executive order are now allowed to proceed because of the stay, what are the potential real-world impacts Justice Jackson warned about for, everyday citizens?
Yeah, she was very direct about the potential consequences. She warned of enormous real-world consequences if EO 14210 is fully implemented. Things like mass employee terminations, widespread cancellation of federal programs and services, and the dismantling of much of the federal government as Congress has created it. She even cited the Ninth Circuit's earlier conclusion, which she quoted that letting this go forward could lead to immense public harm. Examples they gave included things like proliferating foodborne disease or perpetuating hazardous environmental conditions, eviscerating disaster loan services for local businesses, and drastically reducing the provision of healthcare and other services to our nation's veterans.
So really concrete impacts on services people rely on.
Absolutely. And beyond just the immediate services, she also talked about the broader implications for, how our government functions for democracy itself.
How so?
She made this really poignant observation. What one person, or president, might call bureaucratic bloat is, she wrote, a farmer's prospect for a healthy crop, a coal miner's chance to breathe free from black lung, or a preschooler's opportunity to learn in a safe environment. Those details, she argued, they're the result of Congress making policy choices. That's representative democracy at work.
connecting it back to Congress's role.
Exactly. And she linked this directly to that foundational constitutional principle from the famous Youngstown sheet and tube case from 1952. Basically, the president's power, if any, to issue an executive order must stem either from an act of Congress or from the Constitution itself. So Justice Jackson argued that if a president runs roughshod over the carefully crafted statutes that authorize and animate the federal government, then he effectively discards and disables the democratic system.
So we've really taken a deep dive here into a legal battle that I think truly embodies that core tension in our system of government, right? That delicate balance of power between the president, the executive branch, and Congress, the legislative branch.
Absolutely. And what's so fascinating is how the Supreme Court decision, even though it's technically just about granting a temporary stay, it really cracks open these huge fundamental questions about how our government operates. Who really holds the reins when it comes to deciding the future shape of government functions and the services provided to the American public?
Right. And as this critical litigation continues to unfold, it really leaves us with an important question for you to think about. How should we, as citizens, weigh that perceived need for, perhaps, executive efficiency, for transformation, against the often careful, sometimes slower, process of legislative deliberation by Congress, especially when the essential functions of government, things that affect our daily lives, are hanging in the balance?